Welcome back, everybody. News Now Alaska here. We just did a video in the courtroom for 2 Alaska State Troopers that beat up an innocent man. Do me a favor, like, share, subscribe, leave a comment down below, and let's get into it.
Yeah. It's okay to kind of shut up first. This side. Wait, we move over here? Over here. They want something. They want something. Yeah.
Give me a head count in the comments. Tell me how many troopers you think are in this room right now. At the end of the video, I will point them out.
I do have those.
Oh, great. I just don't know the process. I'm just making sure I don't do that anymore.
I do have those, and I don't think I'm kind of happy with them.
Oh, thank you so much.
Yeah.
Just the other one. I'm going to get a transcript. I'll do it. Okay, that's fine. Yeah, we'll do that.
And just to advise everybody, the judge and the state will both be on the phone today. Unfortunately, I was bad there. I'm going to be getting the judge now on the phone. Good morning, this is Shelley with the Kenai Court, and I believe you have everybody ready to go. Yes, he is on the phone, and both the attorneys are here in person. So they're fine. Yes. I mean, we have a media and then some others in the back. Okay, I'll put you on the overhead and then ask you. Okay, we're on record. This is Superior Court. The Honorable Tom Matthews presiding telephonic.
Good morning, sorry, afternoon. afternoon, everybody. This is Judge Matthews. I'm currently in Anchorage. I apologize that I could not get there in person today. But we are here for an arraignment. We are from the state of Alaska versus Jason Allen Woodruff and Joe Miller Jr. They have case numbers 3KN24-00808 and 809. Criminal. I understand we have Mr. Shorey for the state on the phone. Is that correct?
Yes, Your Honor. I'm on a break from a murder trial right now. Thank you.
I was aware that you were in trial here in Anchorage. Thank you, Mr. Shorey. And I have also Mr. Campion. You're there with your client, Mr. Woodruff?
Yes, Your Honor.
All right. Thank you. And I have Mr. Whitmer also there with your client, Mr. Miller?
Correct, Your Honor.
All right. Good morning, or good afternoon, everybody. Thank you. And I understand we have some media personnel as well. So this is some time set for an arraignment for those in the public. An arraignment is simply a time for the court to inform the defendant of their legal rights, make sure that they understand the charges against them, set further court dates, and to enter and take a plea. Let me start, I guess, with Mr. Campion. As your client, does your client have a copy of the indictment?
Yes, he does, Your Honor.
And do you want
Your Honor, sorry to interrupt. This is Daryl Thompson. Just want to let you know that Daryl Thompson's on the line for the victim.
Mr. Thompson, good afternoon. Thank you for letting me know. I appreciate you being here. All right, Mr. Campion, does your client wish to have me read the indictment?
No, Your Honor. Trooper Woodruff waives reading the advisement and enters a not guilty plea.
All right, that's Trooper Woodruff, then I will enter a not guilty plea. Reading an advisement has been waived. As to Trooper Miller, Mr. Whitmer, what's your preference?
Your Honor, Sergeant Miller will also waive reading advisal of rights and enter not guilty plea at this time.
All right, as to Sergeant Miller, that a plea of not guilty will also be entered at this time. Thank you, gentlemen, both, in terms of the reading and the advisement. Let me ask a couple of other questions I need to address. Mr. Miller and Mr. Woodruff, I'm going to do this collectively because the charges against you are both the same. I need to make sure you understand that under the charges that you, in the indictment, you've been charged with assault 1, which is a Class A felony. It carries a maximum penalty of 20 years in prison and a maximum fine of $250,000. Trooper Woodruff, do you understand that?
Yes, Your Honor.
Sergeant Miller, you also understand that?
Yes, sir.
All right, thank you, gentlemen. Okay, a couple of other things I wanted to address. The indictment was issued on October 30. There are notations in the court record that 89 days may have expired under Alaska Criminal Rule 45. I listened back this morning to a couple of things, including the grand jury returns. Mr. Shorey, it was difficult for me to hear precisely what you said, but I believe you said that number was an error at the time of grand jury returns. I also went back to the past pretrial conferences that were conducted before Magistrate Judge Sweet on October 3rd. It appears to me that both Mr. Whitmer, you and Mr. Campion agreed to a January 6th trial date at that time and waived our agreed total time as of October 3rd. So I want to make sure we're all clear on the status of Rule 45. Mr. Shorey, do you have a calculation currently? I recognize you're on a short break.
Yes, Your Honor. Thank you. I have done the calculation. Your Honor, right before arraignment, Mr. Campion filed a motion to dismiss the original information. That old Rule 45, I have that Mr. Woodruff has 0 days run for Rule 45 because it's been told the entire time due to motion work. And then as for Mr. Miller, I have 23 days run. That would be from the date of his arraignment until his first pretrial date, when he then agreed to a date the next pretrial date, and so it's pulled from that October 3rd pretrial date until at least today. So from the state's perspective, 23 days have expired for Mr. Miller and 0 days have expired for Mr. Woodruff.
All right, Mr. Shorey, thank you for that calculation. Let me start with Mr. Campion. As to the state's calculation of 0 days, do you agree with that?
I would acknowledge, Your Honor, there was a motion to dismiss file that is right for the court to decide. And for purposes of today, I don't disagree with Mr. Shorey's calculation. And if I
if I change my opinion, I'll file something with the court.
All right, thank you, Mr. Campion. So let me leave it this way. I'm going to say it's 0 days as of today. If you disagree with that, please file something with the court within a week, if you would.
Yes, Your Honor.
All right, Mr. Whitmer, as to the calculation for your plan, Mr. Miller, 23 days. Do you agree with that number?
I don't, but I'm in the same boat as Mr. Campion, Your Honor. I was not under the impression that we had waived time from the last pretrial conference. However, I will obtain that audio and review it, and if I believe that Mr. Shorey's calculation is an error, I will also file something with the court.
Okay, can you get that done within a week also?
I hope so, Your Honor. It's going to be depend on how quickly I can get that audio recording from the Kenai court, but I will file it as soon as I can.
All right, so again, I'll say it's 23 days as indicated by Mr. Shorey, unless you file something within a week. If you need additional time, simply file a request with the court if you would.
Thank you, Your Honor, I will.
All right, I recognize also that there is the pending motion to dismiss that was filed by you, Mr. Campion. It looks like that had been set for a hearing before District Court Judge Fallon previously, and that motion was vacated when the indictment was handed down. Is that correct? Is there any further briefing that needs to be done on that motion?
No, Your Honor.
All right. I'll get that motion then decided as quickly as possible, unless somebody wants a hearing on the motion.
And Your Honor, from the state's perspective, that motion is moot due to the indictment. That was a motion to dismiss a misdemeanor assault 4. Mr. Woodruff would have to file the new motion to dismiss because the current charge is based solely on the grand jury information.
Okay, so there is no charge based on the information. It's just a single assault 1 charge at this point.
Yes, Your Honor, and I apologize. I haven't gotten into court view to see if they've changed the charge numbers. And I can speak with Mr. Campion after court today to double check if he and I are in the same boat as that. If he's not, I will file something with the court.
Okay, all right, Mr. Campion, I'll leave you to speak to Mr. Shorey then on the status of that motion. If that's in fact moot, if you believe something needs to be further done on that motion, again, if you let the court know within 7 days.
Understood, Your Honor. Thank you.
All right. So in terms of if we're correct that we're dealing with 23 days on one and 0 days on the other, I think we've got some time. The January 6th trial date that had previously been set, let me start with Mr. Shorey. Do you want to keep that date? I recognize that was set when your colleague was there.
Yes, Your Honor. So just so Mr. Whitmer and Mr. Campion know, there, after grand jury, additional information came to light regarding evidence. That evidence is being located and reviewed, and additional supplemental truthful reports are in the works, along with those mentioned that evidence to be transferred to the state for discovery purposes to defense. I don't know if that evidence, I don't know how much of that evidence it is. It has to do with body-worn camera footage from Mr. Miller and Mr. Woodruff that post-date the alleged incident. So I would say I'm fine for January 6th trial, but I'm not certain that my experts are available. Mr. Campion and Mr. Whitmer and I have spoken 2 months ago regarding possible trial dates. My primary expert, I believe, is out of the country in January. No, I apologize, he's not out of the country in January, so we could possibly go in January if that's what the defense requests. But I'll leave that up to them to decide on an appropriate trial date.
Okay. Let me ask Mr. Campion then, from your perspective, that January 6th date still seem workable at this point?
I would say absolutely not, Your Honor. Even without new evidence, we haven't yet had a chance to review the grand jury audio. As you know, the charge is more serious, and we're going to need more time than probably January 6th, especially if there's going to be new additional evidence. I'd recommend that we have a pretrial conference in in December, and then we can assess for the court where we stand.
Okay. Mr. Whitmer, what's your view?
We would agree with Mr. Campion, Your Honor. That seems like the best plan going forward until the state can be discovery complete.
All right, Mr. Shorey, recognizing that you've got some discovery issues there on the statements by counsel for the defense, it seems like a pre-trial conference in December makes sense. Any disagreement?
No, Your Honor.
All right. I'll try to stay away from the latter part of December. How about give you about well, it'll be not quite a month. How about Thursday, December 12th at 3 o'clock?
Your Honor, this is Mr. Campion. I'm not available. I'm traveling for another matter that day, the 12th through the 19th. If we could do it any time between the 9th and the 11th, that would work best for me.
How about the 11th at 3 o'clock?
That works for me, Your Honor.
Mr. Whitmer?
And Your Honor, can we make that 3:30? I have a contentious discovery hearing in Anchorage at 3 p.m.
3:30 is fine for the court. Mr. Shorey?
That was Mr. Short.
I'm sorry, Mr. Shorey. Mr. Shorey, 3:30. Mr. Whitmer, 3:30?
Yes, Your Honor. 3:30 December 11th works for us. Thank you.
And Mr. Campion?
Yes, Your Honor, thank you.
All right, let me ask you a procedural issue. Gentlemen, I recognize this is a Kenai case. All the lawyers are based out of Anchorage. I am currently based in Anchorage. Do you want to do that hearing here in Anchorage in person?
Your Honor, from the state's perspective, this matter should remain in the appropriate venue, which is the Kenai Superior Court.
Okay. I wasn't looking to change venue. It was simply to do for convenience of counsel for the hearing, but we could do it in Kenai.
So, Your Honor, this is Matt Whitmer. One of the things I wanted to bring up to the court is we had filed a consent to proceed when the case was still misdemeanant. Because criminal rules still do allow consents to proceed filed by individuals charged with felonies for certain hearings. So I was going to ask the court whether the misdemeanor consent to proceed that was currently filed is sufficient, whether the court wants to file another one. Because, I mean, as far as I'm concerned, if the court is willing to grant consent to proceed, then Sergeant Miller doesn't need to be at the court hearing on December 11th, and I would appear either in person in Anchorage or telephonically if it's going to be held in the Kenai courthouse. It will cut down logistics and travel time.
Mr. Shorey, any objection to proceeding under the existing consent to proceed?
No, Your Honor.
All right. Mr. Whitmer, I have no issue with proceeding under the existing misdemeanor consent to proceed. It's already on file. I will consider that effective for the new charges as well. So if you want to proceed telephonically in your client's absence, that'll work. Mr. Campion, what's your request? Do you have a consent? I think you have consent to proceed also.
I do, Your Honor, and ask the court to accept it, but I expect that Trooper Woodruff would be present for the hearings.
Okay. All right. So again, I'll consider the existing misdemeanor consent to proceed for Trooper Woodruff to be in effect as well for purposes of that next hearing. So discovery hearing, as indicated, December 11 at 3:30 p.m. in Kenai. For now, I will leave the existing January 6th trial date out there, recognizing that's going to change. I would like counsel to speak in the interim about a realistic trial date so that we can be prepared in December to get that set. Mr. Shorey, is that okay?
That is fine, Your Honor.
Okay, Mr. Campion?
Yes, Your Honor, thank you.
Mr. Whitmer?
Yes, Your Honor.
All right, Mr. Shorey, anything further? Well, I guess let me address the question of bail. Mr. Woodruff is currently out on OR. Mr. Miller is currently out on OR. Mr. Shorey, any requests for changes?
Your Honor, the state believes that both defendants have rebutted the presumption of being a substantial risk to flee and also posing a danger to the victim or the public. That's pursuant to Alaska Statute 1230.011 D2. The state does not request a modification of bail.
All right, Mr. Thompson, you're here for the victim in this case. Do you wish to be heard on the state's position?
I do. Thank you so much, Your Honor. We would ask that there be some imposition of bail. These are very serious charges. My client did sustain very serious injuries. As I mentioned last time we were in court, it's $41,000 of medical expenses, over 300 stitches across his body. He was tased, he was pepper sprayed, he was kicked, he suffered a concussion, stitches in his head, broken clavicle. These injuries are serious, and these charges are serious, and we do believe that some monetary bond should be in place, Your Honor.
Do you have a requested amount?
Yes, 5,000 feet.
All right, Ms. Campion, do you want to be heard?
Yes, Your Honor, I won't repeat what Mr. Shorey said regarding the rebuttable presumption, but I note that since the arraignment of Trooper Woodruff, the conditions of release have been more than adequate. They've demonstrated that he's not a flight risk, he's not a danger to the community, he's abided by the conditions of release that were imposed by Magistrate Sweet. I see no reason to change those conditions or to impose a monetary bond, and I'd ask the court not to impose any such bond.
Whitmer?
Your Honor, I would concur with Mr. Campion. The statutes require you to set bail in the least restrictive means necessary. In addition, I'd like to point out that Sergeant Miller has been subpoenaed to provide testimony in cases and has been honoring the appearance of those subpoenas. So he's not going anywhere. He doesn't plan on going anywhere. He intends to fight these charges. And I believe that his behavior since these charges were filed indicate that he is neither a flight risk nor a danger to the public or the victim in this case. Thank you.
All right. Thank you, gentlemen. So, all right. Have the request from the victim at least to impose $5,000 in bail in this case. The state has not requested a change from the current OR status, as defense counsel has mentioned. The purpose of bail is to address the question of flight risk and to make sure that the public is protected in these circumstances. Both of these defendants have currently demonstrated thus far since these charges were originally filed that they are not a flight risk, and neither has posed a risk to the defendant. I recognize that they are serious charges. I recognize that there are significant medical expenses that are assessed, or at least mentioned at least by Mr. Thompson, and that the injuries involved in these cases were serious. But nonetheless, I don't believe that either Mr. Miller or Mr. Woodruff presents a flight risk or presents a danger to the victim or to society at large in this case. So I'm going to leave bail as currently set. Each will be released on their own for cognizance. Existing conditions, otherwise conditions set, will remain in place. Anything else that we need to address today, Mr. Shorey?
No, thank you, Your Honor.
Mr. Campion?
No, Your Honor, thank you.
Mr. Whitmer?
No, Your Honor, thank you.
Your Honor, we do have the grand jury packets to distribute.
Okay, if you would make note of that, so if you distribute those each to counsel there in court.
Thank you.
Those are distributed, Your Honor.
All right, thank you. So for the record, the grand jury packets have been distributed to each of the defendants at this point. And I believe that concludes the hearing for today's purposes. So thank you, everybody, for your participation today. We will talk to you all or see you in December. Thank you for your recess.
Off record.
Okay, you guys put your guesses in. If anybody guessed all the ones standing up, you'd be right. Not including the half a dozen that are standing out in the lobby. Thanks for watching, you guys. I really appreciate it. There will be more on this coming soon. I'm waiting on body cams. Do me a favor, like, share, subscribe, leave a comment down below. Hit that notification bell so you're notified every time I upload a video or go live. And I will see you guys on the next one. Later.